Thank you for your patience. The panel discussion will begin in a few moments. The theme of this year's panel discussion is Examination of Patent Validity in Court. So first, I will introduce the members of the panel. From the Intellectual Property High Court, Presiding Judge Hibiku Shimizu. From the Court of Appeal of the Unified Patent Court, President of the Court of Appeal, Klaus Grabinski. From the Patents Court of the United Kingdom High Court of Justice, Mr. Justice James Miller. From the US Court of International Trade, Judge Jennifer Cho Groves. From the Abe Ikubo and Katayama Law Firm, Attorney at Law Makoto Hattori. From the Cather Orgenstein Law Firm, Attorney at Law Christoph Orgenstein. From the White and Case International Law Firm, Attorney at Law David Al-Bagli. Also from the Powell Gilbert Law Firm, Attorney at Law Zoe Butler. The moderators are, from the Intellectual Property High Court, Judge Kenji Amano. And from the Nakamura and Partners Law Firm, Attorney at Law Yuriko Sagara. Today's panel discussion will be conducted by these panelists. So I will now hand over to the two moderators. Thank you, Judge Amano and Attorney at Law Sagara.
So welcome back to another session of JSIP2024. I'm your host, Judge Kenji Amano from IP High Court of Japan. And let me introduce my co-host, Sagara-sensei.
I'm Yuriko Sagara. Thank you for joining us.
Okay. Before we start, I'd like to express my gratitude for our guest team to make a wonderful mock trial. I think you usually don't argue or have your discussion on this sort of table or chairs, but you are very flexible enough to do that here. So thank you very much. And
okay, so let me mix some Japanese. And actually, we have three parts for our topics in the panel discussion. And first of all, from judges, we do like to learn actually we do like to have some knowledge from each countries and from region. And after that, we do like to cover the content of the mock trial. And actually, at the third part, we do like to have a recent trend from attorney's viewpoint. And first of all,
okay, let's start. We will have quick remarks from Judge Shimizu from IP High Court. Please welcome.
Thank you, Mr. Amano. First of all, I'd like to welcome wholeheartedly our distinguished guests from abroad. Japan is a big island nation in the Far East, has long been keen to learn from the West. Even still now, we are very curious about what is taking place beyond and outside the border. So we are very grateful to our distinguished speaker today for giving us a wonderful opportunity to learn. Because of the time constraint, there is no Japanese no presentation from the Japanese side. Since most of the audience are already familiar with the Japanese legal system, so we decided it's better to give more time to our guest speakers. It is needless to say there are differences among legal systems because we are different. But what matters is to understand the differences and the reasons behind them. So I'm very much looking forward to the presentation by each speaker and the discussion that follows. Now, I'm returning to the microphone to Mr. Amano so that he can give the floor to our speakers. Thank you.
All right, thank you so much. So let's hand over to Dr. Grabinski first for his presentation, please. Thank you.
Judge Amano, thank you very much. So I start with the first point, my career, and actually there's not that much to say about it, but it is quite similar, I guess, to the career of judges here in Japan, because Germany, like Japan, has a judge career system different from the system in other countries, in particular common law countries, where you first have to be a lawyer and then only later can become a judge. And during my time as a judge, most of the time I dealt with IP cases and more particularly with patent cases. And I also had an interest in the development of a European court, and I was member of a number of committees, including the drafting committee, which drafted the rules of procedure that are currently in force within the UPC. We could move on to the next slide. That's about characteristics of the Unified Patent Court then. And before I address the Unified Patent Court as it is in force since 1st of June 2023, let me use 1 minute for looking back in order to better understand why there's currently the Unified Patent Court. When you go back in the early 70s in Europe and you put yourself in the position of an inventor and you wanted to have your patent protected in Europe, it was a rather burdensome exercise because you had to go to each of the states in Europe, so to France, to the UK, to Germany, to all of the states, when you wanted to have protection, because protection was only possible by national patents. And then when an alleged infringer came up and you wanted to enforce the patent, then again it had to be done on a country-by-country approach, so going to all the national courts. The situation first changed in 1977 when the European Patent Office opened its doors and it became possible to go to just one patent office and get protection all over Europe. However, it was a centralized granting procedure, but what the European patent essentially is, it gives protection like a national patent. So after grant, it gets you back to the approach country by country. And even more, also in order to validate the patent and for renewal fees, it was again a country-by-country approach. So it was felt in Europe that the European system is incomplete, having one column for the time up to grant, one-stop shop only, but then having again the country-by-country approach post-grant, when it comes to enforcement of the patent, but also when it comes to the validation of a European patent. And it took a long time, a lot of effort, but finally the answer to this problem, or the solution to the problem, is the Unified Patent Court. The Unified Patent Court has to be situated into two systems in Europe. which is on the one hand the European Patent Convention, which is the basis for the European patent, which is one system in itself. It currently has 38 member states, including countries like the UK, Switzerland, and Turkey. All countries are not EU member states. So it is a completely different system from the EU system. And on the other hand, you have the EU system. And the UPC had to find its role within these two systems. That's sometimes is the reason why the UPC, with regard to some aspects, may seem to be complicated, comparatively complicated. Could we go back to the slide before, to slide 10, thank you. So back to the Unified Patent Court. So the Unified Patent Court now allows to enforce a European patent and also a unitary patent, which is a European patent with unitary effect, to enforce it in one court only. So it is no longer necessary, if the party chooses to do so with a classical European patent, to go on a country-by-country approach, to go to the courts in the Netherlands, to go to a court in Germany, to go to a court in France, but they can go to just one court, which is the UPC. And what kind of court is this? This is the court of currently 18 EU member states. So it is the same time a Dutch court, a French court, a German court, and I could name all the 18 contracting EU member states. The EU has 27 member states, so what you can see is that still 9 EU member states are not contracting member states of the UPC. For example, Poland, for example, Spain, for example, Ireland. But they are all, the court is open for them to join whenever they want. It is a concept which you may know already also from the euro, so from the currency. The currency, the euro is not the currency in all EU member states. And the same approach applies here with the Unified Patent Court. So some member states, 18, make the step in order to have a court for their, to share, and the others, not ready at the moment, are invited to join. And there was recently a report published by the former president of the Central European Bank, Mr. Draghi, making suggestions in Europe how to further progress also with regard to technology. And it is a clear recommendation of Mr. Draghi that the other EU member states that are not at the moment UPC contracting member states should join the UPC. You see the map of Europe here, and all that you see in dark blue are contracting member states of the UPC. That's a geographical aspect. When you look into economy, the UPC member states cover 3/4 of the gross national product of all of the EU. So you get 3/4 with one court. And also, by the way, with a unitary patent. The other blue, the light blue and the middle blue, they are either have only signed the agreement or not signed, but they are all invited to join. Now, when you look at the green dots in the lower part of the slides, these are all the local and regional division of the maybe just stay there, of the UPC. So the local regional divisions, and they are spread all over the dark blue countries, so the UPC contracting member states. So please move on to the next one. And this is about the competence of the court, the jurisdiction of the court. The Unified Patent Court has jurisdiction on the validity and infringements of European patents with unitary effect, so unitary patents, and also the classical European patents, the so-called bundle patents, unless they have been opted out. Move on, please, to the next one. Here you see the structure of the court. It has a court of first instance with the local, regional divisions and the central divisions. You've seen already on the slide with the map. And decisions from that court can be appealed to the Court of Appeal. The UPC has, with regard to the European Court of Justice, the same position like a national court. And on the left side, you can see that it's also provided for that the court gets a mediation and arbitration center. And we are currently in the process of building this. The director has already been appointed, and he's currently now trying to make everything ready so that the PMAC can open its door as well and is open for the settlement or mediation of cases. Move on to the next, please. Here you see the composition of the panels. So let's start with the Court of First Instance, so the lower part of that slide. And you see that the local and regional division do have 3 legally qualified judges. These are the light blue signs. And they are, in most of the cases, always when it is about a counterclaim for revocation, joined by a technically qualified judge. So when you compare it with the Japanese system, here in Japan, you have technically qualified advisors. So that role in the UPC is filled by technically qualified judges. So they have the position like a judge. That is a difference. And of course, when they are a judge, they are not only limited to decide on technical issues, but also on legal issues. Like also the legally qualified judges, they should not only decide the legal issues, but at the same time the technical issues. So judges with different backgrounds, but with same competence, same status. Central Division has a composition of 2 legally qualified judges and 1 technically qualified judge. And I have also to mention with the legally qualified judges, they're coming from different contracting member states. So it's never a panel only with legally qualified judges from 1 contracting member state. And that's also true with the Court of Appeal, where you can see there's 3 legally qualified judges and even 2 technically qualified judges. Next slide, please. Here you see the structure of the proceedings. So essentially, it is a written procedure where all the facts, all the evidence has to be submitted. That's called front-loading. At a later point of time, it is not possible to add further facts unless you have a good reason for doing so, and the court accepts your reasoning. The court has strict deadlines. They can be extended, but this is rather the exception than the rule. There's an interim procedure, which to some extent, to my understanding, can be compared to the hearings or the meetings in a Japanese proceeding you have with the technically and legally qualified advisors, and you may try to find either better understand the case from the court side or try to find a settlement solution. And for that purpose, in the UPC, there's an interim procedure that aims at preparing the oral procedure, so the oral hearing, and explore possibilities for settlement of the case. And then there's the oral procedure, which, and the court aims at having the oral procedure within 1 year after service of the statement of claim upon defendant. But of course, there are complex cases like JSIP cases where you cannot expect this to happen within 1 year. It will take more time. So I'll move on to the next one. Here you see the language of proceedings dealt with. So, as you know, Europe speaks many languages, and the principle is that all languages are the same, but in practice it's of course not all the same. So what you can see in practice is the following. The local divisions, they offer as language of proceedings the official language, or sometimes even languages, of the state hosting the local division, but always as an alternative, English as the language of proceedings. And there's one regional division, which is the Nordic-Baltic regional division. They offer only English as a language of proceedings. Central division is always the language of the patent, which can be either English, German, or French. So 75% of all European patents have English as the language, 20% German, and 5% French. And the Court of Appeal, the language in the Court of Appeal is usually the same like in the Court of First Instance. Move on to the next one, please. Here you see in practice how this boils down. You see that currently 54% of all cases have English as the language of proceedings, 41 German, 2 French, 2 Italian, and 1 Dutch. And my prediction for the future is that the percentage of German will be reduced and the percentage of English will be increased. Probably more or less the same percentages as I mentioned with regard to the European patterns. So it could be, after some time, roughly 70% English, 20% German, 5% French, and a few percentage with regard to other languages. Please, let's move on to the next one. This is then the third question I was asked: how can an alleged infringer claim invalidity before the UPC? So I'll move on to the next one. There are 2 possibilities to claim invalidity. It is always an action for revocation. So the one situation is that the proceedings start with an action for infringement of the patent, and then it's a counterclaim for revocation that is brought, like the situation we had in the mock trial, or also the alleged infringer or anyone who is a competitor who is has an interest to get a patent revoked can bring an action for revocation of the patent in the central division of the UPC. So these are the 2 ways. It is not possible to just have a defense inter partes of validity. So saying the patent is invalid, but it is only has effect inter partes. It's always either the counterclaim for revocation or an action for revocation, and when then the patent is revoked, it has an erga omnes effect. So it has an effect for everyone. The patent is done retroactively. It is not just a defense between the parties of the litigation. Move on to the next, please. And here you see the composition of the panels. So when it is infringement, action starts first, and then the defendant in the infringement action files a counterclaim for revocation. Then it is going to be 3 legally qualified judges and 1 technically qualified judge, of course, from the technology of the case. And when it is an action right away, then it's decided by the central division in front of a panel of 2 legally qualified judges and 1 technically qualified judge. Next slide, please. Here you see the written procedure, how it works. And what you can see are 3 workflows. So when it starts with an infringement action, then, of course, the claimant submits the infringement action, then defendant files defense, statement of defense, reply, and rejoinder. So each of the parties can submit statements twice. Now, when the defendant of the infringement action lodged the defense, at the same time, they may think of that they want to bring a counterclaim for revocation, so put the validity into question. They cannot do it as a defense in their statement of defense, so they have to file a counterclaim for revocation. Then this goes in parallel. And then again, in this workflow, it goes back and forth. So 2 statements for each side of the parties. And then the proprietor of the patent may think of defending the patent not only with the claim as granted, but wants to defend it also with auxiliary requests by amending the patent. So normally adding another element to the patent claim, and that can be done together with the defense to the counterclaim for revocation. That opens the 3rd workflow. And so at the end, all the 4 workflows have to be finished, and in each of these workflows there's a possibility for the parties for each of the parties to submit statements twice. Please move on to the next one. That is interim procedure. I already mentioned this. And then it's the oral procedure. And in the oral procedure, usually the procedure starts with a preliminary introduction to the case by the judges, normally the presiding judge, based on deliberation. And the deliberation is based on the written submissions of the parties. And then it is followed by pleadings of the parties, more or less you've seen today in the mock trial. And of course also witnesses and experts can be heard, and judges and parties may put questions. And the idea is endeavor to complete the oral hearing in one day. So it's different from what you've heard with the UK trial, when you have a couple of days. And why it can be shorter in the UPC compared, for example, with the UK, it is because there is a front-loading written procedure before. It's not just a skeleton argument. Move on to the next one, please. Okay, and then the decision in a counterclaim for revocation or in action for revocation, it is a total revocation of the patent when the claimant is successful with erga omnes effect in the contracting member states in which the patent has been validated and kept alive. Or it can be partial revocation of the patent upon the request of amendment, again with erga omnes effect, or it can be the rejection of the counterclaim or the action for revocation. Next one, please. How much time do I still have?
Several minutes is okay.
A few minutes. Okay,
minutes.
good. That's good news because
Okay.
I wanted now to share with you the numbers because, of course, it's interesting. You've seen now the theory. It's also interesting how the acceptance of the system is since it is up and running, so since 1st June 2023. And since then, 389 cases have been filed in the Court of First Instance. And you can see it in the bullet points. It boils down to 192 actions for infringement, 103 counterclaims for revocation, 45 action for revocation, so the independent action for revocation, and 49 action for preliminary injunction, preservation of evidence, and inspection. So in the UPC system, there's nothing like a pretrial discovery, but what is possible is preservation of evidence and inspection. And that has been used in the system as well. And then there's even now 96 appeals, but I have to say mainly procedural appeals, because it's possible to already have file an appeal with a grant for leave of the court with regard to procedural decision of the Court of First Instance. And it was the policy of the court to be generous with allowing these kind of appeals at the beginning in order to allow the court to build up at a very early point of time a case law on procedural issues of the court. And that has been done now, and I expect for the future that the court will not grant, allow procedural appeals not to the extent as they have done before, because there's now already some case law in place. However, of course, now the appeals in preliminary injunction, but also appeals on cases on the merits have already been filed in the court. So the Court of Appeal will certainly, in the next future, will become even more busy than it has been in the past. Next slide, please. And yes, now about some case law. There's ample case law, but of course my time is limited here to introduce case law, but I think one decision was quite important. It was the first decision in a preliminary injunction case and of the Court of Appeal, and the Court of Appeal took the chance to lay down some general principles of claim interpretation, and you will not be surprised. They are pretty much the same that users of the system are already used to in the national jurisdiction in Europe and probably also in other parts of the world like in Japan or the US. So the patent claim is the decisive basis for determining the protective scope of the patent. Description and drawings must always be used as an explanatory aid, so like in the UK, as we heard in the UK. The patent has to be interpreted from the point of view of a person skilled in the art, and these principles apply to the assessment of an infringement and the legal validity of a patent alike. Next slide, please. And then there were already some explanation about how to deal with obviousness in the nanostring case. And I think the takeaway from that case is that it can be a starting point for the assessment of obviousness, that a piece of prior art would have been of interest to the person skilled in the art who, at the priority date of the patent, was seeking to find a solution of the problem underlying the patent. So first, define what is the problem underlying the patent, and then find out from the perspective of a person skilled in the art that is supposed to resolve the problem underlying the patent, would that person have considered a particular piece of prior art? And then would there be some incentive, some point or whatever that would allow the person skilled in the arts then to combine the one piece of the prior art with the other piece of the prior art, so that at the end of the day the patent claim has to be considered to be non-obvious, or so to be obvious, or if such combination does not work, then it is non-obvious and the patent is inventive. So in that case, in particular, it was the assumption that one of the pieces of prior art, which was called D6, put forward by the defendant, would have been of interest to the person skilled in the art who, at the priority date of the patent issue, was seeking to develop, and that was the problem, was seeking to develop high-throughput optical multiplexing methods for detecting target molecules in a sample. Of course, I cannot now not go in deeper into the technology of the case. Next slide, please. And now you see a few pictures, a few photos, and that gives you maybe a bit of a European flavor. So you see courts all over Europe where the local divisions or other divisions of the UPC are located, and so let's do a very quick tour to Europe. So on the first line on the left, you see the local division in Stockholm, the regional division in Stockholm, which looks a bit like a medieval fortress, but which is not from the medieval time, but from the 19th century. The next one is the local division of Vienna, so in Austria. The next one is the local division in Hamburg, Germany. And then the lower line, you may know these buildings, that's Ile de la Cité in Paris. But it is not the court, so the court is not in the building you see, but the picture has taken from the local and central division in Paris. But it tells you Ile de la Cité is the middle of Paris, so the local division and the central division in Paris are very much in the center of Paris, and they use also courtrooms in the building you can see on that picture. The next photo shows the Court of Appeal in Luxembourg. It looks a bit like Star Wars building, it used to be the former Parliament building of the European Union. And the final photo is from the local division of Milan. So thank you very much.
Thank you. Let me just quickly summarize in Japanese because it's very important.
For UPC last year in June, we have the EPO at the moment, which is the organisation that people use to obtain their patents. And now we've just created the unified UPC to enforce the patents that are filed at the EPO. That started in June last year. And they also talked about the concept called front loading, which is the idea of bringing all the submissions early, and they can finish the argument in a single day and complete the judgment as quickly as possible. And we have, if we have counterclaims and so on, then the technical judges can enter the proceedings at that point, and then they can add backing and strength to the judgments by the judge. And they've only been working for about a year and 4 months, but they've already dealt with very many cases. As we have discussed, they have also had many injunctions, and they've also, many of these cases have already come to their conclusion. They're working as fast as they can. And Europe is obviously made up of many countries, so English is used as the lingua franca for the court, and it's believed that the number of English cases will increase.
Next, Justice Mera, please make your presentation. Thank you.
Thank you very much. I was asked to address the same 3 questions as Dr. Grabinski, but we managed to cover some of the ground in my introduction to the mock trial, so I can be slightly briefer. Now, we were asked to set out our background, and here's mine. I studied engineering at Cambridge for 4 years, and in between, each summer I went and worked in industry in various countries, and after completing my degree, I went and worked in France and Iraq for a year, because it was only after that that I could get on a conversion course and take up law. And that background is fairly typical of the specialist patent judges in the UK. In other words, I think all of our specialist patent judges have some sort of science qualification at university level, and sometimes a doctorate. And so that explains one reason why during the mock trial I wasn't sitting with any technical advisors. And similarly, Dr. Grabinski described having technical judges in the UPC. We do have a facility, we do have the power in the UK to appoint a scientific advisor to help us. But that doesn't happen it happens extremely rarely. I think I mentioned yesterday that I think over the last 10, 15 years, I can only remember 3 first instance cases where a scientific advisor was appointed. So you may ask yourself, where do we get the technical know-how from? Well, of course, I haven't studied the technology in every case that comes before me, but generally, the specialist patent judges have the ability to understand technical scientific concepts. And we use that to understand the expert evidence that we receive. And it's only in the really, really complex cases that we would resort to a scientific advisor. Now, the other thing I mentioned earlier was the categorization of cases. And I was talking about Cat 4, Cat 5 cases. Oh, sorry. And so there are 2 of us. There's myself and Mr. Justice Mead, and we are the 2 specialist patent judges in the Chancery Division. Now, there are 18 full-time judges in the UK Chancery Division, and we are expected to deal with all the cases in that division. So land, tax, property, trusts, wills and probate, insolvency, and IP. But we have so many patent cases coming through our system that Richard Mead and myself spend almost all of our time hearing Category 4 and Category 5 patent cases. The typical diet recently has been mobile phones, pharmaceuticals, biosimilars, medical devices and some mechanical inventions. And of course, FRAND cases are in some ways the flavor of the month. We've had 3 decided in the UK so far. You'll have heard of Unwired Planet, because that was the case in which Mr. Justice Burse, as he then was, decided that what the parties needed in that FRAND dispute was a global resolution. And in due course, the UK Supreme Court, of course, decided that, yes, we did have jurisdiction to decide global FRAND disputes. And I think my case, InterDigital and Lenovo, was the second case to be decided, and then Optus and Apple was decided very shortly after that. And we are continuing to develop the law. There is one FRAND case which is about to start. It's Panasonic against Xiaomi. We were due to hear 5 FRAND cases this year in the Chancery Division. InterDigital and Oppo has been heard, and the judge, Mrs. Justice Joanna Smith, has finished her judgment, but the parties have asked her to delay issuing it because they're trying to settle the case. InterDigital and Lenovo has also very recently settled. They've decided to take their disputes to private arbitration. So it'll be interesting to see how FRAND cases develop, because after all, we can only decide the FRAND cases that people bring to us. And I have a suspicion that SEP holders are reluctant to reveal all the details of their licensing program, which they have to do for a FRAND case. I mean, there's an awful lot of confidential information in these cases that remains confidential, but certainly in InterDigital and Lenovo, I was somewhat critical of InterDigital's approach. And I think SEP owners don't like that sort of scrutiny. And therefore, my prediction is that the SEP holders will want, if at all possible, to take disputes to arbitration. We will see what happens. But there's one point of distinction between what we can do in the UK and the UPC, for example. Of course, the vast majority of patent cases involve infringement and validity issues. But because of the general jurisdiction that we have in the Chancery Division, we can decide in the Patents Court any case which involves a patent. So inventorship disputes, patent license disputes, which basically are contractual disputes, competition defenses, and so on. Now, my next slide should be familiar because we went through it earlier. Now, I'll just say one or two things more about the Pozzoli case, because in fact, the Pozzoli case was a restatement of a test which originated in the windsurfing case in the 1980s. Now, I happened to be the counsel for the appellant in Pozzoli in the Court of Appeal, and I pointed out that the steps in the windsurfing test were in the wrong order. And Lord Justice Jacobs said, you're right. And that's why we've got the Pozzoli test and not the windsurfing test, because he put the steps into the correct order. So that's the approach that we generally use in the UK. It's not absolutely obligatory for a judge to use the Pozzoli test, but if you depart from this approach, you risk being overturned on appeal, let me put it that way. Now, the other point that I was asked to address were the rules and procedures relating to claims for invalidity. And these rules have been around for a very long time in the UK. And as you'll see on a later slide, these are the minimum requirements. But back when I started as a barrister, patent pleadings were usually very short and very uninformative. So the patentee would simply say, I own this patent, it's valid, and it's infringed because of X, Y, Z. That was it. And the defendant would say, I deny infringement, and the patent's invalid. And the rules have always been that the party challenging validity had to set out their grounds of invalidity. And these, on the few slides, this and the next few slides, are the rules that are applied in the UK. And so you can bring a claim of invalidity either as a freestanding claim, for example, if you want to clear away a patent that is a threat to your commercial plan. But often you've been sued and in a revocation claim, the patentee will often counterclaim for infringement, and then the case proceeds as a normal infringement and validity claim. Or you can claim invalidity as a counterclaim to an infringement claim. And the trend has been for us to require each party to set out their case now with greater particularization. It aids the dispute resolution, it aids the preparation of the evidence, and it certainly helps when you're writing a judgment. So anybody challenging the validity of a patent has to set out their grounds in a document headed grounds of invalidity. Now, there are various detailed rules depending on the ground which is alleged. And what I've set out on this slide are the basic rules for a lack of novelty or lack of inventive step argument. I'll skip over these because you can read these rules for yourselves. There's I mean, it's all fairly basic stuff. If you're alleging insufficiency, you've got to explain what the argument is. Prior use is, you have to be very specific in specifying what use you're relying upon, when it happened, where it happened, etc. And we've got various abilities to order inspection of any apparatus or machinery. But, as I mentioned earlier, in the vast majority of cases, the infringement is assessed by reference to the product and process description that is prepared by the defendant. And if there are problems with it, and there have been cases where we've gone through several rounds of dispute over the PPD and whether it's adequate or not, then we can order further details to be set out. And so, following that theme of greater particularization of a case, if somebody pleads a 120-page patent application and it's said that that document robs the patent of novelty, we will frequently say, you've got to identify the passages in that 120-page document which you say disclose each integer of the claim. And similarly with allegations of obviousness. I mean, sometimes that sort of detailed pleading isn't necessary, but generally if somebody comes at the case management conference and says, we don't really understand what their case is, we will readily order a statement of case to get more detail. And so now that we have infringement by equivalence as part of our law, perhaps not surprisingly, if you want to run an infringement case by equivalence, you have to explain what that case is. Now, I think the last thing I was asked to address was something about the patent of work. And what I've set out on this slide are the judgments that I've given in the last 2 years. So Digital and Lenovo, I think they pleaded infringement of 5 patents, and we had 5 technical trials scheduled. But in fact, before the Fran trial, we only heard 3, trials A, B, and C. Then I heard the Fran trial and set a global rate. And the Court of Appeals said I set the rate slightly too low, so they adjusted it up. You'll see a couple of holidays that I have had from patent cases. Lifestyle Equities was a dispute between 2 polo brands in the trademark field. And of course, Coper and Wright, I had to answer the question, was Dr. Craig Wright Satoshi Nakamoto, the inventor of Bitcoin? And I decided rather emphatically, no, he wasn't, because he forged virtually every document that he put before the court for the purposes of that case. But the remainder of the cases on this slide are fairly typical of the patent cases that we are getting. There are many pharmaceutical cases. So those last 3, a vaccine for our RSV, enzalutamide, I think that's a drug to treat prostate cancer. And Sandoz and Biogen was a technically very complex case about the development of PML in multiple sclerosis patients. And a very important case, actually. How long have I got?
All right. Okay.
So just to summarize in Japanese for you, we're talking about the English court system. The English court have these categories of patent cases based on the complexity of the cases, category 4 and 5. If it's a category 4 or 5, so Mr. James Miller, and then there's one more judge, Mr. Judge Mead. They're the 2 judges with a technical background, and they focus their caseload on those category 4 and 5 cases.
Is this mock trial case will be categorized in level 4 or 5? No.
No, it would be category 2.
Okay, thanks so much.
So basically, he carries out very, very complex cases, so not like we saw in today's mock trial. So looking at the middle of the slide, as you saw, he also dealt with this interesting case, which was COPA versus Wright. This was reported very widely in Japan. This was somebody claiming to be Satoshi Nakamoto, who was the inventor of Bitcoin, and Mr. Craig Wright was claiming to be Satoshi Nakamoto. It took about 3 years.
It takes 3 years or more to handle the rights case?
Yes, I mean, this was the preliminary issue in about 4 actions. So he brought claims for copyright infringement, database right infringement, and passing off. And basically, he was trying to take control of the whole Bitcoin sphere. But all the claims depended on whether he was or was not Satoshi Nakamoto. And so we heard that as a preliminary issue. And that put an end to, I think, 5 actions, actually. He's just started another one.
This is widely reported in Japan, and so Mr. Justice Miller's, your judgment was widely publicized in Japan on this case. So I'd like to move on to the next case now. Thank you very much.
Thank you so much. Let's move on to the presentation from Joe Groves. Joe Groves, please.
Thank you so much for inviting me here today. I'm happy to meet you all. So they've asked me to speak to you about a few topics. Litigation at my court, which is the U.S. Court of International Trade. Also invalidity under the U.S. patent law, as well as some recent issues of interest. So also to start with my biography, unlike my esteemed colleague judges here, I do not have a technical background. But I find that I enjoy learning about new technology, and it has not been a hindrance for me in my career. I've spent my career Now I've been a lawyer for 30 years, and I've done mostly intellectual property, international trade, and litigation. And I've not had a problem without having a technical background. So in my country, in the US, we have federal judges that are appointed under Article 3 of our US Constitution, which means that I was nominated by the President of the United States. In my case, it was President Obama, and then I was confirmed by the US Senate. It's a very long process. It took almost 2 years for me to complete that process from beginning to end. And they interview hundreds of people. Everyone that I know for 30 years, going back to when I was a very young student, all the way through my current career when I was nominated. And they talk to judges that I appeared in front of. They talk to my colleagues. They also talk to lawyers that I appeared against in my career. They wanted to know what experience they had litigating against me. So it was a very difficult process, and what happens in the US is that once you are confirmed by the Senate as a federal judge, it's a lifetime appointment. So there's no term limit, there's no age limit. So as long as I am healthy and do not break the law, I can keep my position for the rest of my life. So it's a very prestigious position, and I feel very honored to have that position. So as I mentioned, I worked in intellectual property and international trade through my career. I also worked at the White House. So I did work for President Obama, and I also worked for President Bush. So I spent 5 years. This is my court. It's in New York City. It's the picture on the right is the ceremonial courtroom. We have 9 judges in my court, and we have 5 senior judges who take reduced caseload after the age of 65 if they choose. It's their option. Now, in my country, we have federal jurisdiction over cases or controversies, so there can be no advisory opinion. So there has to be an actual dispute between parties. Some of the subject matter that we cover are disputes under the US Constitution, under treaties, and various areas of law such as patent law or international trade. We have 94 district courts, which are the trial courts of first instance. That is where patent cases are heard. And generally, the judges who hear patent trials in the US do not generally have an IP background. You may find a judge that has an IP background or technical background, but it's not a requirement. So there are some judges, for example, who spent their entire careers doing criminal law, and they become a federal judge, and they may be hearing a patent case. So it's not a prerequisite. And so we have developed certain areas, certain geographic areas that have, where the judges have IP expertise. So for example, you may have heard about Delaware District Court. Many patent litigations are brought there because companies file for incorporation in Delaware. Also, Texas has a lot of litigation in IP there, where the judges, many of the judges have expertise. Also, California, of course, with Silicon Valley, there are many cases brought there, and New York as well. Then the appeals of all patent cases go to the Court of Appeals for the Federal Circuit, which is based in Washington, D.C. And most of those judges also have a patent expertise, not necessarily, though. It's also not a prerequisite to becoming a judge on the Federal Circuit. And then the appeals there go to the US Supreme Court. So to tell you a little bit about my court, it's the US Court of International Trade. We are a specialized court. We handle international trade and customs cases for the entire country. There's only one court in the US that handles international trade cases. That's my court, and we have national jurisdiction across the entire country. So some of the types of cases we hear are anti-dumping, countervailing duties, customs classification cases. So it's a civil court, so we hear cases of civil penalties and damages. So generally in my court, I handle cases as a single judge sitting by myself. However, in certain special cases, we will appoint 3 judges on a panel. Usually those are cases of very significant impact to the US economy or that involve US constitutional issues. So one example is you may remember when President Trump was in power, he issued sanctions against a lot of different products, and mostly steel products, steel and aluminum products. So we had 4,000 complaints filed challenging the president's authority to issue those sanctions. So we appointed a 3-judge panel, and I was one of the judges on that panel, and we reviewed whether the president had the authority to issue those sanctions. We looked at national security laws, and our panel held unanimously that the president did have the authority. And then there were multiple cases brought after that, all relating to intellectual property sanctions that were brought on various products. So that's one example of the type of case where we would have a 3-judge panel. So transparency is very important in our court. So for every decision, I write a lengthy opinion. We publish that on our website for the court. So anyone can read those. They're always published only in English. But generally, we write very long, complete opinions so that in my view, I understand, because I have an international audience for the types of cases that I'm handling, I want everyone to understand the court's reasoning. So I'm assuming that there are US businesses and lawyers reading my opinions, but also companies and lawyers in, for example, Japan or Korea or China reading my opinions, and I want them to also understand the court's reasoning because they are also importing products into the US, and these decisions are going to impact those companies and the lawyers who are advising those companies. Also, my appeals in my court go to the Federal Circuit as well, and so we're also trying to explain the court's reasoning to the Federal Circuit and to the Supreme Court eventually. So just some examples of intellectual property cases that are handled in my court. These are a list of some of the cases I've done in recent years. The first case involved gray market goods, which are actually authentic products that were authorized for sale outside the United States, and then an importer tries to import them into the United States for sale, and they have not been authorized for sale inside the United States, so we call those gray market goods. The second case involved IP infringing goods, counterfeit products. And then third type of case that I handled was involving 337 exclusion orders. The orders were issued by the International Trade Commission, but when the products were stopped at the border by customs, and it was alleged that the products coming into the US were infringing and violated the 337 exclusion order, that's an example of a type of case that I handle in my court. So also in my court, we often sit by designation, which means that we can sit in other courts, other federal courts within the United States. When I do that, it's by invitation of the other jurisdictions. So for example, I've sat very frequently in the Ninth Circuit Court of Appeals and the Second Circuit Court of Appeals, also district courts, which is the trial level in Delaware, hearing mostly patent cases, as well as the Southern District of New York and various other jurisdictions. So normally the chief judge of the other district will invite me to come sit, and I usually request IP cases, and then it has to be approved by the Chief Justice of the US Supreme Court. And so I've been handling cases for many years in other jurisdictions. So I won't spend a lot of time talking about how to bring a claim for invalidity under the US patent laws, because I think we touched on a lot of these issues during the mock trial. I will just say that generally I try to conclude a trial within 18 months if possible, from beginning to end. Generally, I ask the parties at the very beginning of a case to agree amongst themselves how long they want the case to take from beginning to trial. And that includes discovery, it includes filing dispositive motions, and it includes filing motions for hearings as well as for trial. And generally, I do not give extensions unless there are very short extensions, because in our federal rules, Rule 1 is the speedy resolution of cases, and I'm very mindful of that. I try to finish cases as quickly as possible. Just skip through some of the cases as we've mentioned. Let's see. Obviousness is a question of law, which is based on the underlying facts, and that is through the KSR decision from the Supreme Court in 2007, which we discussed during the mock trial. Obviousness requires a showing of clear and convincing evidence that a person of ordinary skill in the art would have a reasonable expectation of success in achieving the claimed invention. And just to mention some recent issues of interest, one issue that I've been seeing lately is with respect to willful infringement. So in the US, if there's been a willful infringement with knowledge of the patent, a plaintiff might be entitled to enhanced damages. So often that can be triple damages, which we call treble damages. So the plaintiff needs to show constructive knowledge or actual knowledge. And one interesting issue in the District of Delaware, where I handle a lot of patent cases, is what suffices to show knowledge. So generally, it's always been accepted that a cease and desist letter that is sent to a defendant can serve as knowledge, constructive knowledge of the plaintiff's patents. But the question is whether a complaint filed in court can also serve as constructive knowledge in lieu of a cease and desist letter. And there's a split among the judges in the court. The majority of the judges believe that a complaint can be sufficient knowledge of the plaintiff's patents, but some judges say that that is not enough, that there instead needs to be a cease and desist letter filed. And I am of the view, I've issued opinions stating that I'm in the majority view, where I think that a complaint can be sufficient knowledge instead of a cease and desist letter. But this issue has not been ruled upon by the Federal Circuit or the Supreme Court, so that's an issue that could be coming in future years. Also, another interesting issue is third-party litigation funding. So we've had this happening in the US for at least the last 20 years, where companies will often buy a patent portfolio. Many of them are non-practicing entities, which we call NPEs. They don't actually make any products. They just own the patents. And then what happens is these companies will just file lawsuits and hope to get settlements. And it's become actually a business where there are financial companies, sometimes they're venture capital firms, sometimes they're actually third-party litigation funders, and they will fund litigation based on these patent portfolios and fund the lawsuits around the country. It's a growing problem because what happens is it creates a lot of volume in the U.S. courts, and the judges have to handle these cases, and it increases the workload on everyone. And it also slows down resolution of other legitimate cases. So usually, the funders are not required to disclose their existence. So this happens in secret. But some judges in the U.S. have started to require the disclosure of a third-party litigation funder. And it's created some interesting dynamics where parties have objected because they don't want to disclose that they're being funded. And I think there are certain judges who believe that it's important for ethical reasons to know who the parties are and who has a vested financial interest in every case. Also, if there are settlements, it's important to know who the parties are that have a financial interest. So I think it's relevant to know if there's a party that's not, it doesn't appear on paper in the court. You might not know it exists, yet they might have control over whether a case settles and the terms of that settlement. So it's been estimated that litigation funders had approximately $15.2 billion in assets allocated in U.S. litigation just last year in 2023. And also, it's been estimated that non-practicing entities who hold patents only for litigation filed almost 50% of the patent cases in the U.S. in the past 20 years. So this is also an issue that's gaining a lot of attention in the U.S. legal system, and there's been some movement to try to figure out perhaps legislative solutions. So that's an interesting issue to watch. And then just one last issue that I wanted to raise. I understand there's a lot of young attorneys who are here and who are watching online, including my law clerks back in the U.S., if they're still awake. I have a standing order in my court where I encourage the parties to allow young lawyers who do not have any litigation experience to handle an issue. And I allow the attorneys to split the issues. So what I'm encouraging is the senior lawyers to allow the young lawyers to come into my courtroom and handle just one issue. It can be a very short issue, maybe 2 minutes. And my hope is to help train the future generation of litigators. And what I find is that because I have a written order, often the clients or the lawyers can show that to their clients, and they can say, oh, this judge encourages young lawyers to come to court. And I know very often the senior partners are very reluctant to give control to a young lawyer, but you know, I look at it as very important to training the next generation. I also think back to when I was a young lawyer, and the first time I was in state court and federal court, somebody gave me a chance. And I have to say, the young lawyers are always very well prepared. They're very nervous, so they're extremely well prepared. And they always do a wonderful job. And I think it's a good way for them to gain confidence, and also for the partners to get confidence and say, oh, this young lawyer is smart and prepared and can handle this matter, this issue, and hopefully they'll give them more chances as they get more senior. And it's also something that a lot of judges are starting to do in court. And I do understand some of the cases that are before me are worth billions of dollars. And I understand that it's very difficult. So it's not a requirement, it's just an encouragement. And if the client feels that it's a $5 billion case and they do not want a junior lawyer arguing an issue, that's fine. But I hope in smaller cases, on a one-issue basis, that younger lawyers will get a chance.
Just to summarize in English, as what Judge Gross said, he talked about the having young lawyers taking part in the court cases in order to raise and develop the younger generation. And this order, the suggestion to senior judges to allow younger judges to take part in court cases and to make them more confident is extremely important. And I was very happy to hear that explanation. And we would like to do the same thing to encourage our younger lawyers as well. I am also, I still regard myself as young, but what I mean, younger people than me. So moving on to what they said, we talked about the federal cases for patents, and as Judge Groves talked about, she discussed the international trade cases, and she covers a very wide range of cases, and including IP infringement as well. And often we have to go to Texas, and a lot of our cases that we're involved in take part in Texas, and a lot of these infringement cases are held in states like that she discussed. And also, finally, at the end, the Judge Groves talked about Delaware and her work in Delaware. And as I'm sure you know, Delaware. There are many companies that are incorporated in Delaware, which is why that state has a lot of patent cases there. And we also have a lot of cases involving companies involved in Japan that she is dealing with. And finally, my last point is that this is a problem in the UK, in the US, has happened from before. The issue of NPEs, the companies are actually not manufacturing these parts, and so they're just supplying money to cause lawsuits in order to earn money and creating a business. And she discussed that issue in some depth. Thank you very much.
So this is a chart of each jurisdiction from the conclusion of each jurisdictions. So is it correct? Is it all right? Hey. To our surprise, every single decision of each issue are exactly the same among all jurisdictions. Is that correct? Okay? Okay? Yeah. So I wanted to speak why that's happened, but I don't have enough time to do that. So how to do that? First, I'd like to ask Judge Cho Groves about the Markman hearing, because in the mock trial, there was a Markman hearing, and after your decision, you asked the party to have an intention to settle. Is it the common thing to happen in the United States?
Yes, it's, so as I mentioned during the mock trial, we have a bifurcated proceeding where normally about 6 months after the case is initiated, we do a Markman hearing for claim construction. So it's fairly early in the case. I think it goes back to Rule 1 that I was talking about in terms of efficiency and a speedy resolution. I think it's an efficient system because the judge gives a claim construction ruling early, and then the parties can assess then how they want to proceed with the case. So it narrows the issues for trial. And very often after I issue a Markman ruling, the cases will settle at that point. That's very common. And I'll just also remark, I think the difference in styles was apparent when I do a hearing, even a bench trial, I think of it as a conversation between the lawyers. I do not like it when the lawyers come in and read their brief or have a prepared statement. And because my thinking is that I've already read all the briefs, I already understand their argument, and I just want to get to the difficult question that I have. So very often I will even issue questions in advance. So I read all the briefs and then I issue questions so the lawyers are prepared to just talk about a few issues in detail. and we go in depth. And I don't want just to have lawyers read their statement to me. I think that's a waste of time, so I don't think that's very efficient. Also, one thing I always recommend is that the lawyers listen to each other. And they did that here today in the mock trial, where the lawyers were responding to each other. I think that's the best type of oral argument, where we are all asking questions of each other and exploring the issues together, trying to come to an answer.
Thank you so much.
And not reading.
All right.
As mentioned, there is something called a mark my hearing at the early stage of a patent dispute. Fulfillment and invalidity are not deliberated at the same time in the U.S., unlike Japan. Claim construction comes first in the U.S. in order to expedite the procedure and to make it more efficient as well. So that was done during the mock trial today as well. And as you saw in the mock trial this morning, halfway through the oral examination, oral discussion, the judge would intervene. And this is a style commonly seen, as I understand, in the U.S. as well. So even if the attorneys are well prepared to argue, the judge may intervene. That would activate the argument and promote or create an impetus for a settlement as well.
I'd like to ask you, Dr. Grabinski, your approach is here. This is a 5-step here, and this is a similar. I think this is similar, but not identical to the problem solution approach frequently used by APO. So your approach is there any difference between your approach and PSO? How do you think about that?
Well, we have currently the nanostring case, and there's another one that has been issued by the other panel of the UPC Court of Appeal, the Mammoth case, which goes more or less along the same lines like the nanostring case. So in the nanostring case, there were put forward a couple of prior art documents, and the court, well, it was a preliminary injunction case, came to the conclusion that with regard to one prior art, so the D6, which I already mentioned, that it was more likely than not that the patent would be invalidated because it will be invalidated because of obviousness. So, well, there was one piece of prior art. So why should the court say anything which is the closest prior art? That's one prior art that did the job for the defendant in the case, and that's good enough. And so normally in a litigation, when it comes to revocation action, the parties argue different prior art documents, and then they say, okay, either document 1 or document 1 and in combination with document 2, or document 3 in combination with document 4. With regard to this prior art, the patent is, what is claimed was obvious for a person skilled in the art. And then in a litigation, from a court's point of view, there are two ways to deal with this. So the court has to look at all these argued prior art documents, and when the court comes to the result that there is one that with regard to which the patent is what is claimed is obvious, then they pick this one, and they then argue why it is, give reasons why this is obvious, or they have a look at all and they come to the result that it is not obvious. Then they have to deal with all the prior art in order to exclude this. But so in light of this situation in litigation, at least I don't see, at least in general, no necessity to to say which is the closest one of these.
Okay.
And even I discussed this with members of the Board of Appeal, of the EPO Board of Appeal, and they are telling me, no, well, we are not only looking at the closest prior art, we are also looking at other prior art, maybe the second closest or the alternatively closest prior art. And the same approach is the approach of the UPC, at least as has been developed up to now. And so I don't see there a lot of differences. I think it goes along the same lines. And,
all right.
I think we had harmony between the 4 mock trials today, but I think there's also harmony between the UPC and the EPO Board of Appeal, to my understanding.
So, because this is a patent matter, if you can bear with us, at the UPC, a problem solution approach is taken. And in the UK, this is an approach taken in the EPC. It's a very stringent inventive step approach. And Judge Gravinsky is saying that for the nanostrings case, which he presided, in the first instance, the problem solution approach was stringently applied. But in the second instance, where Judge Gravinsky presided, that was not as explicit. So the problem solution approach, whether UPC would apply the problem solution approach, was something that was of interest. The one feature of the problem solution approach is to use the closest priority art, or to pick what is the closest priority art. That's one approach, but as Judge Gravinsky mentioned, sometimes too much attention is focused on which is the closest priority art. Prior art, what is the closest prior art sometimes is dwelled on too much, so not much difference overall. As a conclusion.
Asked Justice Miller, and I found, in your opinion, you took a Pozzoli test in the mock trial, but I found, in your opinion, I can read, quote, that in some cases it is helpful to answer this question by adapting the structured approach set up in Pozzoli. In other cases, it is helpful to adapt the PSA favored by EPO. But neither approach can replace the statutory question itself. It must be assessed by reference to the facts and circumstances of the case, unquote. What is the underlying idea of your phrases here?
Okay, in this paragraph, I wasn't saying anything new. Actually, I was summarizing a number of paragraphs from the judgment of Lord Hodge in Activis and ICOS in the UK Supreme Court. And Lord Hodge's judgment in that case is the latest word on the law of obviousness. But in this, what's going on, there are 2 things going on here. One is, there's been a long-standing theme in the appellate courts in the UK to try and align our approach with that of the EPO. And so that is part of what's going on here. The other thing is, there's been discussion of the difference between problem solution and Pozzoli in many cases. And Lord Justice Jacob in Activis and Novartis, in I think 2010, he explained that the problem solution approach can be used in many cases, but sometimes it creates a problem of its own. And to give you an example, if you have to identify the objective underlying problem, but the invention, at least part of the invention, is identifying there is a problem at all, that approach can lead you astray. That's one of the reasons why we tend to favor the Pozzoli approach in the UK. Mm-hmm. But it's not forbidden to use the PSA.
Mm-hmm. Right.
Yeah.
Well, in case of England, in the judging of the inventive step, you are using Pozzoli, and actually in the case of mock trial this time, you use this method, but you made a recent decision, and you said which test is not really good, and actually, by knowing that the problem can't be solved, therefore, and basically anyway, there are cases in England, and actually the appropriate method must be chosen and must be used to judge it. That is a kind of, the main pillar of your opinion. And if the same method is used all the time, of course, sometimes it will not function very well. And actually, I accept it like that.
I hand the mic to the Sagara sensei.
And actually, this is the question to the Mr. Augenstein of UPC. Actually, in many of Japanese lawyers or the people to choose opt-out, but Mr. Augenstein have lots of experiences in UPC. Therefore, I do like to know what is going on in UPC, including merit and demerit.
So, Mr. Augenstein, what are your thoughts on the pros and cons of filing a case before UPC? And are there any trends in UPC practices Japanese companies should pay attention to as a would-be defendant?
I might refer to the picture Judge Grabinski presented at the very beginning of his presentation, showing which countries participate in the UPC already. And I always compare, the number of inhabitants of those 18 countries that are already participating in the UPC with the US. And they are more or less the same number. So you have 300 million inhabitants plus within those 18 countries, which is more or less the same number of inhabitants. Yes, I think they have 350 million or something. So, but the thing is, when you go to the UPC, you more or less get clearance for a market of the same size of the US, but for only a fraction of the cost. Because I also believe that the rules of procedure and the UPC provide for a very streamlined procedure. We have front-loaded procedure. We have an interim conference which also allows the court to focus on the important issues so that you can really go through invalidity and infringement within 1 day. So that's the whole purpose of the rules of procedure. So there you see, again, a very efficient system to resolve all those patent disputes. And I think that's the biggest advantage, that you have a clearance for the whole of Europe, and it's somehow kind of the next logical step after we had the European patent for many decades, that you then also, reform the enforcement, not to go on a country-by-country basis. And what I also find is very convincing is that you have a lot of very experienced judges at the UPC. So I just recently had the first hearing at the local division in Mannheim, and it was really impressive, the lineup of judges. We have Judge Tochtermann, part of the Presidium, working full-time at the UPC, a former presiding judge of one of the chambers in Mannheim. You have Judge Böttcher sitting there, still presiding judge at one of the divisions in Mannheim, and the international judge was Judge Brinkmann for the Netherlands, also a very experienced judge. So this is really kind of an impressive panel. And I can say for all of the German judges and for most of the Dutch judges I know personally that they had been in their role before. So you have a really experienced lineup of judges that look at the cases, so where you can, presume that they will look to the right issues of the case and will come most likely to a proper decision. So when we look at the cons or the disadvantages, I'm not so sure whether it's really disadvantage, but what I can say is that I think the approach is a little bit more formalistic of the UPC, so that you apply rather strictly deadlines, formal issues, rules regarding delays, late filings, and so on, so that you have to be very careful to watch on these steps. And another thing that is unfamiliar, at least to German litigators, is that you are only allowed to comment if you're invited to. So you might have seen a scheme Judge Grabinski presented with more or less 2 filings at every stage, so 2 filings for the infringement proceedings, for the revocation action, for the amendment of claim. Apart from that, you're not allowed to just send something to the court.
So not just before the oral hearing like we did in Germany very often, a week or 2 weeks before, kind of a summary. You're not allowed to do that. And if you want to have like something formally filed, like change of language proceedings, there are distinct possibilities in the case management system. So you have to deal with that at some point and be aware of it, that there's this very formalistic approach. And there's only one thing, there's a famous Rule 9 request, which is for general procedural measures, so we're not foreseen elsewhere. And there had been some creative German litigators trying to misuse that for kind of general submissions or summary of submissions. And I can say to you and confirm that the Court of Appeal didn't like that and simply ignored those filings. So that means you have to really prepare on that one, so it's really more formal. But whether it's a good or bad thing, I don't know. Another disadvantage might be, but I think it's become less and less, is that we have, of course, a completely new court system without any precedents. So we have some uncertainties going on. But you can mitigate this risk by going to local divisions with 2 national judges, where you can expect that they handle those procedural issues more or less like as they did in the national proceedings.
So we've heard from Mr. Augustine about the UPC and the number of cases that he can resolve, and it's extremely impressive system, and it is very clear all the proceedings that are going on, and obviously it's a very formal court system. It's more formal than the local court systems. The deadlines are fixed, and the parties are expected to submit everything on time, and no extensions are allowed. And that may have been a disadvantage, and but because the court is new, there's also a disadvantage, but that will be resolved as we go forward.
Didn't you have any experience that as a defendant attorney that not so much prepared for being sued, because it sounds like really too strict?
Yeah, well, I think you need to be prepared for it because you have strict deadlines, so you need to attribute resources to your team. And probably you got to have you give them some freedom, because as there might be a lot of procedural challenges with very short deadlines, coordination might not always be possible. So kind of be ready to give, some freedom to your litigator, maybe to decide smaller issues on their own with not so much coordination going on, because there's really time is of the essence. So this is something I think should be bear in mind, that because of the short deadlines, you can't go into every detail, and should accept that maybe some things have just to go and try to have an opinion filed on time.
Thank you.
I want to add one thing which might be interesting, not about the UPC, but about the UP, which is also there on the slide mentioned. So the unitary patent. The EPO publishes a dashboard, and it is updated every day about the numbers of applications for unitary protection, and also the patents that were granted, and the so-called uptake rate, which includes the applications as well as already the granted, where unitary protection was granted, is roughly 25%. So which means that from each European patent, every 4th is a unitary patent. And that has also cost reasons, because roughly you can say you pay less than you would have to pay for the validation of 4 national parts of a European patent. You pay for the whole unitary patent, so you get protection in 18 contracting member states. That may be one reason for this. And when you look at who is trying to get unitary protection, that is also transparent on the dashboard of the EPO. It tells you that, from the top 25 proprietor, number 1 is a US company, number 2 is a German company, number 3 is from Korea, number 4 is from the US, 5 and 6 Sweden, so again UPC, 7 US, 8 China. And the first Japanese is number 23.
Number 23.
So that is, of course, it has to be seen. There are pros and cons in that regard. So it's certainly a cost effect. If you want to have protection widely spread all over Europe, then unitary patent is, to my understanding, is something to be considered. When it is good enough to have protection in 1 or 2 key member states, just only the big economies in Europe, so just only France and only Germany, then it might be better to just have a classical European patent and only have these 2 countries covered. That is a business decision at the end of the day. But it is interesting really to see who is applying for unitary patent. Sometimes it was also said it is just something for the companies with the big pockets, but it is not true. It is 1/3 of the application are SMEs. So it's probably the technology-driven SMEs that are applying also for unitary patents.
So he's just saying that Japanese companies are not using the UPC very much. We'd like Japanese companies to use it more.
So next to Ms. Butler, I heard that during the mock trial, you mentioned the agreed common general knowledge, CGK, which sounds unfamiliar to the Japanese audience. So could you describe the purposes and merits of preparing this statement of agreed common general knowledge? And also, could you introduce some distinctive features of England practices compared to the other jurisdictions?
Sure, of course. Hopefully, one of the things that came across in the mock trial from the UK team was the central role of expert evidence in our proceedings. So, as Mrs. Justice Mellor explained, the parties, as part of the procedure, submit written expert reports, and those stand as the experts' evidence in chief and will be the subject of cross-examination, live cross-examination at trial. And typically, those reports will set out the technical background to the patent and will cover what that expert or each expert believes was the relevant common general knowledge at the priority date. And there's often, between the experts from both parties, a significant degree of overlap and agreement, and there will also inevitably be issues in dispute. And sometimes it's quite difficult for the parties, and perhaps even more importantly, the judge going into trial, to know where there's agreement and where there's dispute. So a practice has developed in our court, actually very much at the instigation of the judges, and the parties are now encouraged and actually, in fact, often ordered, after exchange of expert evidence, but before trial, to prepare what's called a statement of agreed common general knowledge. And the idea is it's a document that the parties agree, sets out what's agreed to be part of the common general knowledge, and typically also identifies those points where there's dispute. And so the advantage is going into trial, it's much clearer where the parties agree and where the judge will be particularly interested to hear what comes out of cross-examination, where there are points of dispute. And then normally what happens after trial is that the parties will update this statement of agreed common general knowledge to reflect the evidence as it's come out at trial. So, for example, in the mock trial that we just heard, there was a sort of a dispute potentially about whether flaps with protrusions were part of the common general knowledge. So it may have been that prior to trial that was identified as a point in dispute. But the fact we sort of agreed between us was that it would emerge during cross-examination that in fact both experts agreed that it was common general knowledge, and then the parties would have updated the CGK statement. And I think from the judge's perspective, coming to write the judgment, it's an extremely useful document, and I think I think I'm probably allowed to say this, quite often is copied and pasted into the judgment because it's very clearly something that the parties agree and is uncontentious.
Yeah, I mean, it saves us a lot of time. And yeah, we do use these statements almost verbatim. I mean, we do add a few edits of our own, but yeah, they do save a lot of time, actually.
And just to flag a couple of other points, perhaps of distinction with our practice compared to those in other, particularly I would say European jurisdictions. And again, I think there are things that perhaps emerged during the mock trial. One is the very significant role in our system of oral advocacy and live expert and fact witness testimony. So arguments are very much developed orally by the advocates, often very much it's very interactive with the judges. They're very proactive in asking questions. And cross-examination, live cross-examination of experts is a really central part of our system. And again, I think the mock trial perhaps demonstrated that, where there were things that seemed apparent on the basis of the written expert evidence which changed or were revealed to perhaps be only part of the picture during cross-examination. And then the only other thing, perhaps given time to perhaps mention, is, and again it's something that Mr. Justice Mellor mentioned in the mock trial, is how flexible our system is. This may not be a point of distinction with other European countries, but I think it is definitely a real feature of our litigation, that it's very flexible in terms of actually both case management, so the tools that the judges have at their disposal to ensure the efficient and fair conduct of proceedings, but also in terms of the types of issues they can consider and the types of relief that they are prepared to grant. And I think a lot of the SEP-FRAN cases that Mr. Justice Mellor mentioned are a very good illustration of how our courts try to be very commercial and grapple with commercial issues.
Thank you. Mr. Al-Baghawi, about the U.S. hot topics.
Thank you all. And as a hot topic that I wanted to mention, today, of course, we spent a lot of time at the trial talking about obviousness, which is a very involved element to the law. But I'd have to say that one of the hottest topics now is Section 101, patent eligibility, Tokyo Tekikakuse, desu ne? And this area, we could spend a day talking about the developments in Section 101 and what it means. Now, in Section 101, it only asks that you provide a claim to a process, a machine, a manufacturer, or a composition of matter. That's basically what is in the statute. On the other hand, we have judicial exceptions to what is patentable subject matter that has come out through case law from the Supreme Court. And so if it's deemed that your claim is directed to an abstract idea, a law of nature, or a natural phenomenon, that may be a basis for invalidating your claims. So what do you do in litigation? What do you do in prosecution? In litigation, if you're the defendant, then know that you can use Section 101 as a basis for invalidating the plaintiff's patent. And you can bring your claim for invalidity immediately. So as soon as the plaintiff files the complaint, you can then go and file a motion to dismiss based upon the patent being invalid under Section 101. So you don't even have to wait till you get to trial. And this is going to color the proceeding as you go along. On the other hand, if you're the plaintiff, you need to support your patentability. And I'll just be very short here and say, talk to your colleagues who are prosecuting the patents, because your basis for supporting your claims in litigation is going to be basically the same arguments that the prosecutors need to make to get the patent issued in the first place. So those ideas are very much aligned. When we talk about prosecution, of how do you avoid having your claim being viewed as nothing more than an abstract idea or nothing more than a natural phenomenon, the general guidance is to be specific. Show how your invention has practical application, right? And so this has been written about now for more than 10 years. And so there's many places where you can go and find this. But let me just say that as much as this is a problem now, everyone practicing patent law is aware of this. Everyone from the USPTO to the federal court judges who have come out in public and said this is very much a difficult issue and we would like guidance. So even in the face of that, the Supreme Court has, over the recent set of years, denied all petitions for certiorari. And so the general feeling is we're probably not going to get an opinion from the Supreme Court anytime soon. So as a result, I would direct your attention to legislation. Maybe Congress is the answer. And there has now been a lot of concerted efforts in recent years to get legislation passed. And there's many stakeholders. We have patent companies and patentees who are on both sides of the issue, and some would like the situation that it is, some would like to reform the patent law. But I think as a prosecutor, again, what you need to do is try to be specific, think about filing continuation applications so that over time, if the law changes, you can take advantage of it at that point. And in the meantime, maybe we just need to pray for a legislative miracle. So with that, I'd just like to conclude my thoughts.
Thank you. Thank you for introducing the hot topic in the States. And lastly, finally, Mr. Hattori, could you introduce the present Japanese practice regarding the use of technical experts or progressive court hearings and evidence collection procedures in patent infringement litigations?
Okay, thank you very much. I'd like to comment on the 3 points very briefly. First is the use of technical experts. In the UPC, the US, and the UK, it seems that expert testimony with cross-examination by the parties is often adopted. In contrast, in Japan, as demonstrated in today's mock trial, full-time judicial research officials called Saibansho Chosakan and part-time technical advisors called Senmoin provide information to judges. It is also widely practiced in Japan for the parties to have technical experts prepare written opinions and submit them as evidence. But such experts are rarely cross-examined in the courtroom. The neutrality of judicial research officials and technical advisors is rarely questioned. However, the parties are not allowed to ask them questions. And it is unclear how and how much they influence the court's decisions. Therefore, it is sometimes difficult for me to explain their roles and significance to my client. Although rarely used in today's patent litigation practice, an expert system called containing does exist in Japan. And it is possible for the court to designate a technical expert as containing and have the parties question him or her to ensure that the judges have accurate information about the technical issues. Based on today's symposium, I was reminded that depending on the case, it may be beneficial to consider using such a system. Next, I'd like to mention court procedures. As Judge Grabinski and Mr. Christoph Augenstein explained, the UPC is required by rules to conduct strict and expeditious planned procedures. It is quite impressive that the timing of the filing of documents, including application for amendment of patent, is set out under the UPC system. In Japan, although there are some differences depending on the division of the court in which the case is pending, I have the impression that the court schedule is not so rigid. Judges proceed with court hearings on a case-by-case basis, trying to balance the need for speed and the need for full and thorough trial. I do not feel that there is any strong opposition to such a comparatively flexible approach in Japan as a way of conducting ordinary lawsuit. However, with regard to the provisional disposition procedure, it would be meaningful to obtain a preliminary injunction order more expeditiously. In Japan, there is a procedure to seek a preliminary injunction called karishobun against patent infringement. but the speed is not so different from that of an ordinary lawsuit. The defendant can submit a defense of invalidity and other defenses, and usually it takes more than 10 months to obtain a preliminary injunction order. In cases where there is an urgent need to seek an injunction, I think more expeditious decisions would be desirable, providing that the patentee yields a certain amount of security. Finally, I'd like to refer to evidence collection procedures. Although unrelated to today's mock trial, the major difference between Japan's system and other ones seems to be in the evidence collection procedures. I understand that in the UK, US, and UPC, there are systems which disclose the alleging infringing act, and they are commonly used in practice. In Japan, there are also systems such as the preservation of evidence, called shoko hozen, the order to submit documents called shorui teitsu meirei, and the investigation system called sashou seido, which was introduced in 2020. We could find the manner and nature of the alleged infringing act utilizing these systems while protecting defendants' trade secrets. However, preservation of evidence is rarely used in preliminary in today's patent infringement suits. The issuance of an order to submit documents is also rare. And I have heard that an investigation order has never been issued. As a practitioner, I'd like to actively try to utilize such evidence collection systems in order to contribute to further realization of justice and fairness in court. Thank you very much.
That's the end of the panel discussion. Thank you so much.
That was the end of today's panel discussion about the examination of patent validity in court. Thank you to all the panelists.